न्यूज नशा, आदत हर खबर की।
सुप्रीम कोर्ट में मंगलवार को एक केस की सुनवाई के दौरान भारत के प्रधान न्यायाधीश डीवाई चंद्रचूड़ और एक वकील के बीच मजेदार बातचीत हुई। दरअसल औद्योगिक शराब से जुड़े मामले की सुनवाई के दौरान पेश हुए सीनियर वकील ने चीफ जस्टिस से अपने कलरफुल बालों के लिए माफी मांगी। वकील ने होली का जिक्र करते हुए कहा कि उन्हें उनके कलरफुल बालों के लिए माफ किया जाए। इस पर सीजीआई चंद्रचूड़ ने मजाक करते हुए पूछ लिया कि इनके बालों का शराब से कोई लेना देना तो नहीं है। बार एंड बेंच की रिपोर्ट के मुताबिक वकील ने कहा, मेरे रंगीन बालों के लिए मैं माफी चाहता हूँ। ये होली के चलते ऐसे हो गए। यही होता है जब आपके आसपास बहुत सारे बच्चे और पोते पोतियां होते हैं। इस पर सीजीआई चंद्रचूड़ ने मुस्कुराते हुए पूछ लिया, इसका शराब से तो कोई लेना देना नहीं है ना? इस पर वकील ने हंसते हुए जवाब दिया। उन्होंने कहा मैं विस्की का फैन हूं। इस दौरान सीनियर वकील ने कहा, 9 जजों के सामने बहस करना, वह भी कागज रहित अदालत में, माय लॉर्ड, मेरे लिए चुनौतीपूर्ण है। इस पर सीजीआई ने कहा, अरे नहीं, इससे तो काम और भी आसान हो जाता है। आप आसानी से एक पेज से दूसरे पेज पर जा सकते हैं। तभी वकील कहते हैं, आपकी उम्र के लिए तो ठीक है, लेकिन इस पर सीजीआई बीच में कहते हैं, आप क्या कह रहे हैं? मामले की सुनवाई सुप्रीम कोर्ट की 9 जजों की संविधान पीठ कर रही थी। इससे पहले सीजीआई के सामने विस्की की 2 बोतल लेकर पहुंच गए थे वरिष्ठ वकील। इससे पहले 2 शराब कंपनियों के बीच ट्रेडमार्क उल्लंघन विवाद की सुनवाई के दौरान भी मजेदार किस्सा देखने को मिला था। इसी दौरान सीजीआई के सामने 2 विस्की की बोतलें पेश कर दी गई थी। ये बोतलें वरिष्ठ वकील मुकुल रोहतगी ने सीजीआई के सामने पेश की थी। सीजीआई की अध्यक्षता वाली 3 न्यायाधीशों की पीठ मध्य प्रदेश हाईकोर्ट के आदेश के खिलाफ एक अपील पर सुनवाई कर रही थी। इसमें इंदौर स्थित कंपनी जेके एंटरप्राइजेस को लंदन प्राइड नाम के तहत बेवरेज बनाने से रोकने के लिए शराब कंपनी पेरनॉट रिकॉर्ड की अपील को खारिज कर दिया था। इसी सुनवाई के दौरान सीजीआई और जस्टिस जेबी पारदीवाला और जस्टिस मनोज मिश्रा के सामने दोनों बोतलें पेश की गई थी, जिसके बाद सीजीआई जोर से हंसे और कहा कि आप अपने साथ बोतलें लाए हैं। बाद में सीजीआई से पूछा गया कि क्या वो दोनों बोतलें जो पेश की गई हैं उसे ले जा सकते हैं। इस पर सीजीआई ने मुस्कुराते हुए जवाब दिया, हाँ प्लीज ले जाइए। ये वाकया ज्यादा पुराना नहीं है और आज जब कोर्ट में चर्चा हो रही थी तो उस वक्त कॉफी और विस्की की एक लंबी डिस्कशन सीजीआई के सामने हुई। आइए आपको दिखाते हैं कोर्ट के वो पल।
Of alcoholic drinks. So whenever they refer to beverage form or something that can be had as it is, neat as just there Article 47 refers to that as intoxicating drink. So a whole lot of different phrases have been used in different entries. There has to be some purpose behind it, and that is what my endeavor would be to show why. But in any case, at least one assumption I can make is, when we read entry 51 list 2, when it says alcoholic liquors for human consumption.
There is one reason possibly why they said, otherwise liquors would have been sufficient. Why do they use intoxicating liquor?
I'll ask that is a question which legal history, the state of law, which preceded our constitution,
as Mr.
that indicates.
Mr. Datar will tell you if you go down south, or Mr. Giri will tell you that even when somebody serves you coffee, they'll ask you, do you want to have the liquor? When you have the coffee liquor, it's not the decoction. The decoction is very often referred to as a liquor, but it's not intoxicating liquor. Tea liquor, yeah, absolutely. Tea liquor, coffee liquor. So it's liquor, but it's not the intoxicating liquor. Therefore, we have a history in our country of alcohol. It's not alcohol, but it's still referred to as liquor.
Not when we're talking of whiskey and liquor, Lord, the coffee liquor seems to be a little. Coffee liquor is a different.
I know. Coffee liquor is very different.
I know.
Liqueur.
That is L-I-Q-U-E-R.
U-E-R.
Liqueur it's called sometimes.
Yeah, spirits. It is spirits.
My real problem in this matter is what is the learned Attorney General going to argue when you people are done? See, because
Lord, the bigger problem would be what most of the lordships would do, Lord, without understanding what liquor is.
that's true. That's true.
That would be a bigger problem.
The attorney's whole argument is going to be purely theoretical.
Or you can argue it's a coffee part.
Attorney, you have an uphill task.
No, let him have liquor, Lord, he'll conquer the hill.
The lighter side again.
Actually,
I was appearing.
look at other way
Chief
around.
Justice Datu.
Some of
the
us would
Kerala
like-
High Court.
can do it more impartially. You know nothing about liquor.
On
can
a
be more
sales
impartial.
tax on hatcheries. So then question was about 301, 304, etc. Chief Justice Datu asked me, Mr. Venkatramani, how much did you know about chickens? So I said, I don't know about the internal motion, but I know about the motions from state to state. So that was talking about coffee, the Kumbakonam degree coffee, which is the highest
Yes.
coffee. Yes. There's a very important question. Liquor other than intoxication and intoxicating liquor.
That's it.
Therefore, that's the secret of entry 8. Will address your lords on that.
Attorney doesn't sound very convincing with regard to coffee liquor, Lord. He must graduate on to the liquor part.
Yes, Mr. Devi.
Now coming back, Lord, to the kindly have, Lord, the Lordship has seen it's a taxing entry 51 list 2, and duties of excise, which means tax on production and manufacture. Now the Lord, the parallel entry is there in the union list, entry 84. Lordship would have to see it before the amendment, because now 2016, GST, etc., has really spoiled the shape of the entries. Pre-2016. It would be there in the footnote, perhaps.
Yes, we got it in the footnote. You have to thank Mr. Shankarnarayan for producing this masterpiece. No, that page 471.
Yes. The parallel of this entry in the union list, because for tax purpose, it seems framers divided the this end, alcoholic liquor for human consumption and alcoholic liquor not for human consumption. So liquor was divided into two categories. Now, coming back to entry 51 again, Lord, with due respect, Lord, I'm sorry, there was something which I should have pointed out earlier. It contains three items, in fact. Your Lordship would see alcoholic liquors for human consumption, that's one item. The other item is opium, Indian hemp, etc. And the third item is medicinal and toilet preparations, which are in the exclusion clause, but not including medicinal toilet preparations containing alcohol.
So all these cough syrups which have alcohol will go to the center.
For tax.
For tax.
For tax. But the interesting part which I wanted to really emphasize here is, there is no regulatory entry in any of the lists, either specifying the word industrial alcohol or stating alcoholic liquors not for human consumption. There's no legislative entry in any of the lists, list 1 or 3.
So does it mean that industrial alcohol is not meant for human consumption?
Obviously, it can't be had because the
Nature of
strength of the liquor is not 95%, 97%, not 90 to 95%.
Yes.
So which is dangerous for health, perhaps.
Mr. Dwivedi, you just said no regulatory entry in any list using the phrase industrial alcohol or I missed actually.
Or alcoholic liquor not for human consumption. I can understand not if the idea was to regulate these two, tax these two, then there should be some regulatory provision somewhere. Intoxicating liquor is one such entry, Lordship may keep it in mind. But apart from that, there is no entry to regulate industrial alcohol or alcoholic liquors not for human consumption. And more importantly, Lord, if Lordship will see medicinal and toilet preparations containing alcohol, there is no legislative entry in any of the lists. And the question, therefore, which comes to my mind, which I raised before Lordship, and I'll try to answer that. Why? Taxing entry only regulates part of it, the intoxicating liquor or alcoholic liquor. But the rest of the parts are where we don't know. We have to speculate. Synthetics puts it in entry 52 because of IDR. Now, if we put it in entry 52, then obvious thing would be that it goes to entry 24 then. Because you can't pick up from any other entry excepting 24, so far as industry is concerned. So if we place it in entry 52, then per necessity it must go to entry 24.
But medicinal preparations containing alcohol, we go to list 1.
No, but which entry?
Entry 97.
No, I'll answer that. No, that's not. If entry 97 has been determined to be so huge, then what was the point in having these entries? They could have just said list 2 and 3, entry 97. But it would have included everything.
But a medicinal preparation containing alcohol, then the duty of power to levy duty of excise, where will that go according to you?
No, duty of excise is there, entry 84.
Right.
Entry 84, list 1,
right.
It clearly includes
medicines.
Unamended. Answer. Right. It includes. So that's what I'm saying, Lord. The idea is to have these items as separate items, but for tax only, but not for regulation.
So entry 84 will cover medicinal preparations which have alcohol.
For taxation.
Act, of course, yes.
So what appears apparently is that unless we look into the legislative history of this word intoxicating liquor and the laws pertaining to alcoholic liquors.
Now we have seen the entire gamut of entries, right?
Man.
Now why don't you formulate what your points are?
Yes.
So then once we do that, we'll go to synthetics and see. It's not a very long matter.
No, it will. You'll have to trace the legislative.
Obviously, but why don't you formulate it?
I would not be able to make it.
No. Obviously, we'll look at the legislative history of intoxicating liquors. But now you can just formulate what your submissions are.
Yes. The first question again is, as I pointed out,
we've made a note at page 29, page 30, PDF page 30. But now why don't you formulate what your points are?
Not the first question which I'm going to canvas for Lordship is that entry 8 list 2, which confers exclusive jurisdiction on the states to regulate industrial alcohol.
Which confers exclusive
jurisdiction on the states to regulate industrial alcohol. Because industrial alcohol is part of intoxicating liquor. So the scope of entry 8.
Industrial alcohol is part of intoxicating liquor.
And therefore states have exclusive jurisdiction.
So your first submission is entry 8 of list 2 confers exclusive jurisdiction on states to regulate industrial alcohol because industrial alcohol is part of intoxicating liquor.
Intoxicating liquor, not to pay, note it down. Not the intoxicating liquor is a general term.
Yes.
Unlimited. It has not been restricted by any phrases before or after.
It's a general term.
Unrestricted by any other entry, unlike 24. To put it in a better formula, it's a specific entry. Industry is a general entry. This is a specific entry which at least 3 constitutional benches of lordships have held that to.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।